Welcome to the Touchpoint video series by the Global Restructuring Group of Norton Fulbright. My name is Kei-Jin, and with me is Sue-Ann Gan. The purpose of this series is to highlight developments in the restructuring and insolvency regimes in various jurisdictions. Today's episode is entitled The Rise of Singapore. The insolvency space in Singapore has been a relatively exciting one over the past few years. There have been quite fundamental changes which have been made to the insolvency regime here, and they are embodied in the new and comprehensive Insolvency, Restructuring and Dissolution Act 2018, otherwise known as IRDA. But before we go any further, perhaps we should ask ourselves why Singapore is so focused on becoming a major restructuring hub. Sue-Ann, perhaps you can give us your views on that.
Thank you, Kei-Jin. Now, Singapore is a hub in many aspects already. We are a major financial hub. We are also a major legal hub and a business hub. We are also becoming a digital asset hub. And more importantly, we are also a maritime hub. And between all these hubs, we also have the arbitration mediation hub. And in line with Singapore's vision to become a leading dispute resolution hub, so many things were made to its insolvency and debt restructuring regime in the last few years. And today, Singapore has gained traction as the center for debt restructuring in Asia. So in response to your question on why is Singapore focused on being a major restructuring hub, I would say that the main driving force is really because it complements many other areas in which Singapore takes pride in. We have a trusted legal system. We have first-class judiciary. We have good governance and very attractive business and financial institutional environment. And we want to capitalize on that. And from a creditor and a debtor point of view, I would say this really gives confidence because there is already a very good infrastructure in place to achieve a fair outcome in a restructuring.
Thank you, Sue-Ann. There was a very deliberate plan on the part of the government to make Singapore a restructuring hub. A law reform committee and other committees were set up to look at what it meant to be a hub and what it needed to get there. The necessary reforms were enacted. These were done in phases. First, amendments were made to the Companies Act, and after that, a standalone Insolvency, Restructuring and Dissolution Act was passed. There was a fundamental shift in the nature of the insolvency regime in that it became much more like a Chapter 11 debtor in possession restructuring regime and approach. Automatic moratoriums of much greater reach were introduced, along with cross-class cram-downs in the case of schemes of arrangement. Super priority for rescue finance was introduced, and pre-pack schemes of arrangements as well. More recently, restrictions upon the enforcement of ipso facto clauses in an insolvency event were introduced. The courts also worked hard at and continue to work hard at issuing judgments to ensure that we have sufficient jurisprudence to provide certainty for stakeholders and other parties who are interested in restructuring their debts in Singapore. Further, a rules committee was also formed by the courts to receive feedback from users of the Singapore courts to ensure that the process was constantly evolving and improving to suit their needs. So, and perhaps you could tell us a bit more about these amendments.
Thank you, Kei-Jin. You've mentioned earlier that Singapore has an improved scheme of arrangement, and this really means that the courts are now able to impose a global moratorium of up to 30 days as soon as the application is received. And this can be extended to related companies such as subsidiaries. And with these improvements to the scheme, it kind of Singapore has taken a bit of flavor from the US Chapter 11, and this is very much similar to the English-based framework. Basically, this could lead Singapore companies who have assets and creditors worldwide to choose Singapore instead. So I can give an example from a shipping perspective. So restructurings are often complicated in maritime matters because of the international nature of maritime. Maritime and offshore businesses often have complex structures for their loans. There can be many jurisdictions involved. For example, vessels can be flagged in various jurisdictions, owned by SPVs in other jurisdictions. And these reforms really have made Singapore very attractive for restructurings because foreign companies can now have access to Singapore's restructuring processes.
Thank you, Sue-Ann. Another key change was the introduction of the UNCITRAL model law on cross-border insolvency to allow foreign insolvencies to be more easily recognized in Singapore. Since the introduction of the model law, there has been an increase in the number of foreign insolvency practitioners here who have sought recognition in Singapore for the purposes of obtaining information and discovery and for commencing claims. This is great for the R&I ecosystem here in Singapore. There is a very close working relationship between the Ministry of Law, the judiciary, and R&I practitioners so that best practices from all over are picked up, discussed, and where necessary, implemented quickly.
Thank you for sharing the reforms that Singapore has made so far. Shall we move on to the SICC in terms of the role of the SICC in cross-border restructuring and insolvency?
Thank you, Sue-Ann. On the 1st of October 2022, the SICC or Singapore International Commercial Court rules were amended so that the SICC would have jurisdiction to hear cross-border restructuring and insolvency matters. This meant that the SICC can now hear proceedings related to corporate insolvency and restructuring or dissolution under IRDA. The catch here is that the proceedings must be international and commercial in nature. But the requirement of being international in nature is not difficult to satisfy. It is international in nature if it is a proceeding commenced pursuant to the UNCITRAL model law on cross-border insolvency, and it is international in nature if the debtor company is a Singapore incorporated company or a foreign company with a substantial connection to Singapore that satisfies a list of factors. For example, this would be satisfied if the debtor company has a place of business in a foreign country, or the debtor company has at least an asset or property in a foreign country, or the debtor company has at least a liability that arose in a foreign country. These are just examples.
Thank you, Kei-Jin. So yeah, that's right. In October last year, many positive changes took effect. To sum up, there were two main changes. First, the SICC can now hear cross-border restructuring and insolvency matters, such as schemes, judicial management, winding up. And this really means that the SICC can hear proceedings relating to corporate insolvency, restructuring and dissolution under the IRDA, or the Companies Act as it was enforced before IRDA. The catch is that these proceedings will have to be international and commercial in nature at the commencement of the proceedings. And the second most important change is the ability for a foreign lawyer registered with the SICC or a Singapore qualified lawyer practicing in a foreign law firm to make submissions before the SICC in a restructuring or insolvency proceeding. So this is an important change because companies now operate worldwide and they can engage international law firms to represent them in any restructuring or insolvency matters. Now, Kei-Jin, I had a question on mediation. How do you see mediation working in a restructuring?
Mediation will become a very important tool in restructuring cases in Singapore with the adoption of the Singapore Convention on Mediation in 2019. The joint SMU IPAS graduate certificate in insolvency and restructuring welcomed its inaugural intake in March last year, and it is an important part of enhancing the regional restructuring ecosystem. INSOL is proud to have been able to contribute to the development of this course with the preparation of the Ethics and Professional Practice in Singapore module for the graduate certificate. INSOL International's Asia Hub will now also continue to prioritize collaborative engagement throughout the region, while INSOL's globally recognized training and education programs, including new courses with a focus on the Asia-Pacific region, will help to equip current and future leaders in the profession with the knowledge, experience, and understanding to contribute to a global restructuring community. There is a very close relationship between the Ministry of Law, the Judiciary, and the R&I practitioners who work cooperatively to seek out, discuss, and introduce best practices. All this in order to make Singapore a much more attractive restructuring jurisdiction. With that, Suen and I hope that we've been able to give you a useful insight into the insolvency and restructuring regime in Singapore. If you have any queries, please do reach out to me or Suen or Mei-Yan in our Singapore office, and we will try to help you as best as we can. Thank you.